everyone. Hope you all are doing well. Warm greetings to all. I, Dr. Shikha Dhaman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, is again in front of you to deliver another lecture on the topic, the grant of Diwani rights, working of Dyarchy and Anarchy. Let's begin with an introduction. The East India Company increased its trading activities in India by getting permission from the Mughals and other local rulers. Simultaneously, the East India Company designed strategies to become a political power in India, taking advantage of the decline of the Mughal Empire and the rise of regional kingdoms in the 18th century. In order to become a paramount political power, the Britishers had to eliminate other European companies involved in expanding their trade and political influence in India. Besides this, the Britishers had to wrestle with the regional powers like Marathas, Mysore, Sikh and others to extend and consolidate their empire in India. The grant of Diwani, that is revenue, rights had its origin from the East India Company, which was established by the Britishers from the Charter of 1600 by Queen Elizabeth. Dyarchy system in Bengal. Earlier, the Nawab of Bengal used to carry out two functions, Nizamat, which implied the military power and criminal justice, and the Diwani, which stood for revenue collection rights and administration of civil justice. The Treaty of Allahabad of 1765 resulted in dual administration or Dyarchy in Bengal. The British got the Diwani rights, that is, the authority to collect the revenue and the power to dispense with criminal justice. Also, the administration of Bengal was to be left in the hands of Deputy Subedar, who was nominated by the company and could not be removed without prior permission from the Britishers. Therefore, the British not only had the military power and the rights to collect revenue, but also controlled judicial and police powers. This implied that the East India Company had all the powers but no responsibilities, while the Nawab had to bear all responsibilities without any actual power. The reasons behind the British policy to employ the system of Dyarchy in Bengal were many. If the company had directly taken over the administration in its own hands, its imperial designs could have been exposed before rise and consolidation of British power. Secondly, the company lacked the manpower and the resources to take over the complete administration and control in their own hands, as it required good knowledge of local customs and practices. The court of directors of the company was more interested in the economic and material benefits without any administrative responsibilities on their shoulders. Furthermore, the political powers in the hands of the company could have resulted in increased intervention and regulation by the British Parliament. This Dyarchy system created an inefficient and impractical system in the long run, which led to anarchy and chaos in the Bengal. The company relegated the responsibilities of the Nizamat to various sub-Diwans, due to which inefficiency in law and order started appearing. The company refused to accept and responsibility, while the Nawab found himself lacking the necessary means to do so. The responsibility of the revenue collection was auctioned off to the highest bidders, and this affected the peasants too much. Development of agriculture was neglected, which was one of the reasons for the disastrous famine of 1770s. The handicrafts, for example silk industry, were destroyed as they could not resist the onslaught of foreign products, which were duty-free while their own products were taxed. The resultant monopoly of the English in trade made it unprofitable for the artisans and small manufacturers to continue in their profession, and they were reduced to the status of landless peasants. By that time, Warren Hastings was appointed the governor of Bengal in 1772. The failure of the system of administration of Bengal was introduced by Clive already evident. Therefore, he did away with the dual administration and took the reins of administration directly in his own hands. Hence, in less than 2 decades, the company emerged as a sovereign master of Bengal. The first Diwani rights were guaranteed by the Charter of 1726. Some of the features of the Charter of 1726 are just discussed now. Number 1. The Charter authorized the governor and the council of 3 presidencies to make laws and impose punishments for their contravention. These were not to be effective unless approved and confirmed by the company's court of directors in England. Next point. The charter also established Mayor's Court in Bombay, Calcutta and Madras, and also introduced English laws in these presidencies. In 1757, the Battle of Plassey, very important, took place and the company defeated Sirajuddaulah, Nawab of Bengal, and laid the foundation of British Empire. Later, in 1765, Shah Alam granted Diwani rights of Bengal, Bihar and Orissa to the company, the responsibility of collection of revenue, which also involved the civil administration. Thereafter came the Warren Hastings Plan of 1772. After the Britishers had acquired the Diwani rights of Bengal, Bihar and Orissa in 1765, there came up the concept of mufassils, which was used to refer to territories which surrounded the presidency towns that were brought under the control of Britishers. Warren Hastings went on to introduce a scheme of judicial administration in 1772 alongside a system of revenue administration which went on to lay foundation of Adalat system in India. Under this plan, the territory of Bengal, Bihar and Orissa was divided into multiple districts, and in each district an English servant of company was appointed as the collector, who was to be responsible for the collection of revenue along with the having the judicial powers. Now let's talk little about the Adalat systems that were prevalent in India. Small cause courts. These courts were present in each of the village and used to deal with small or petty cases. Decision of these courts were binding up to the value of Rs 10 only. These courts were headed by either the village headman or the head farmer. Next were the Mufassil Diwani Adalats. These courts were present in each district and had jurisdiction over the revenue and civil cases, including the disputes relating to marriage, inheritance, caste, debt, contracts, disputed accounts, property, partnership, personal demands, etc. It used to have the pecuniary jurisdiction of Rs 500, such that the decisions of this court up to this amount was full and final. The collector of the district used to act as the judge of the court, who used to work in assistance with the native law officers such as qazis and pandits. Another was Mufassil Nizamat Adalat. These courts were also known as Fauzdari Adalats. These courts were also present in each district. It only dealt with the criminal cases. Further, it is very important to mention that these courts were not empowered to try the cases involving death sentence or cases demanding feature of property of the accused, as such cases were to be submitted to the Sadar Diwani Adalat for the final orders. These courts were presided over by the Muslim law officers only. The Maulvi used to expound the law, while the Qazi and the Mufti used to give fatwa and render the judgment accordingly. The collector had the supervisory functions. He used to see that all the necessary witnesses were heard, that all the cases were tried regularly and that all the judgments are impartial. Next type was Sadar Diwani Adalats. This was the apex court for civil cases in the province. It used to have both the appellate as well as original jurisdiction, as it not only used to hear appeals from the Mufassal Diwani Adalat but also used to take up cases which involving dispute of rupees 500 or over. It used to charge 5% of the amount of dispute on each petition or appeal. It was presided over by the governor and his council and was located in the presidency of Calcutta. Next, Sadar Nizamat Adalat. This was the apex court for the criminal cases in the provinces. Similar to Sadar Diwani Adalat, it also used to have both original as well as appellate jurisdiction. It used to have specific jurisdiction to decide over the matter of death sentence and forfeiture of the properties. In case of death sentence, the death warrant was prepared by this Adalat and was to be signed by the Nawab as the head of the Nizamat. This court was presided over by Daroga Adalat, who used to act as the judge of this court. He was assisted by a chief Qazi, a chief Mufti and 3 Maulvis. Under this, supervisory functions were performed by the governor and council, who used to keep a check over the functioning of this court. Then came the Regulating Act of 1773. In 1765, after the Battle of Buxar, the East India Company secured Diwani rights in the states of Bengal, Bihar and Odisha. This made the East India Company as a commercial cum political establishment in India. This led to the resultant administrative anarchy and accumulation of an insane amount of wealth by the company servants was being questioned in the British Parliament. As a result of which, the British government set up a secret committee to probe into the affairs of the company. The report submitted by the committee paved the way for the act submitted by the Parliament known as Regulating Act to enforce the governmental control and regulate the affairs of the company. Now let's discuss some of the features of the Regulating Act of 1773. The Regulating Act of 1773 asserted that the right of British Parliament to regulate the affairs of the East India Company. Next, the Presidency of Bengal was made supreme over those of Bombay and Madras. The Governor of Bengal was then designated as the Governor General of 3 provinces. The Governor General was given the full power of superintendence, direction and control over 2 remaining territories. Warren Hastings was appointed then as the Governor General through this act. The act also appointed Governor General and 4 councillors for the Presidency of Bengal. The council was vested with the power of superintendence and the control of the government of Bombay and Madras Presidency. Also, another point was that the Governor General was assisted by 4 councillors. Their tenure of office was fixed for a term of 5 years. The Governor General was also required to follow the orders of the directors of the company and keep them informed about all the matters which were related to the interest of the company at that time, and also he was given the power to make rules, ordinances, regulations for the overall improvisation of the governmental control over the company owned territories. Very important feature was the Supreme Court of Judicature at Fort William was established at Calcutta, and it was considered to be the apex court, which consisted of Chief Justice and 3 other judges. The act changed the constitution of the Court of Directors of the company and strengthened the control of British government over the company. The Governor of Bengal was designated as Governor General of Bengal. Lord Warren Hastings was appointed as the Governor General of Bengal. After this Regulating Act, another act that came out was Pitt's India Act of 1774. It introduced to remove all the defects and loopholes that existed in the Regulating Act of 1773. It was named after the British Prime Minister, that is William Pitt. The Act distinguished between commercial and political affairs of the company. A joint government of the British India run by the Crown and Company was established. The government had the ultimate power and authority. A court of directors was formed consisting of 6 commissioners was established for political affairs of the work. Court of directors also managed the commercial affairs of the company while the political affairs were being managed by the Board of Control, that is BOC. Governor General's Council was reduced from 4 members to 3 members. Also, Governors' Councils were established in Madras and Bombay. After that, another act that came into picture at that time was the Charter Act of 1813. This charter took away exclusive trading rights from the East India Company. The trade was thrown open to all British merchants. The regulations made by the Council in India were required to be laid before the British Parliament. It allotted Rs 1 lakh to promote education to Indian children. Financial provisions were also made to encourage a revival in Indian literature and for the promotion of science. Christian missionaries were also allowed to spread the religion in India. Another act came that was in the year 1833 as named as Charter Act of 1833. Governor General of Bengal was designated as Governor General of India, and it is very important to mention that Lord William Bentinck was appointed as the first Governor General of India. It vested the legislative power solely in the hands of Governor General in India. The Council was empowered to make laws and regulations for all persons. This Charter Act of 1833 legalized the British colonization of India. India's first Law Commission was set up under the Act and Lord Macaulay was made its chairman. After this Act, another charter was the Charter Act of 1853. This charter actually created a separate legislative council for India consisting of 12 members. Local representation was introduced for the first time in Indian legislature. Provinces for recruitment in civil services on the basis of open competition were also introduced. Finally came the Government of India Act of 1858, the very important act. The rule of the company was now replaced by the rule of Crown in India. The powers of the British Crown were to be exercised by the Secretary of State for India. He was assisted by the Council of India having 15 members with him. He was also vested with the complete authority and control over the Indian administration through the Viceroy as his agent. The Governor General was now made the Viceroy of India. Lord Canning was declared to be the first Viceroy of India. And finally, this act also abolished the Board of Control and Court of Directors. Now coming to the next, that is the Indian Councils Act of 1861. Now this Act of 1861 actually enlarged the Council of Governor General for making laws by adding not less than 6 and not more than 12 members. Half of them were non-official members. It introduced Indian representation in institutions like the Viceroy's executives and legislative councils. 3 Indians entered the Legislative Council at this time. Legislative councils were established in centres and provinces. It provided that the Viceroy's Executive Council should have some Indians as well as some non-official members also while transacting the legislative businesses. It accorded statutory recognition to the portfolio system. Further, it also initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras province. Ultimately, after this act, we came with another act, that was the Indian Council Act of 1892. Now, this act introduced the concept of indirect elections, what we call as nominations. It enlarged the size of legislative councils. It further enlarged the functions of legislative councils and gave them the power to discuss the budget and address the questions to the executive. After this act, we have Indian Councils Act of 1909, another very important in the Indian history. This act is also known as the Morley-Minto reforms. Direct elections to the legislative councils, first attempt at introducing a representative and popular element. This act changed the name of the Central Legislative Council to the Imperial Legislative Council. The member of Central Legislative Council was decreased from 60 to 16. It also introduced a system of communal representation for Muslims by accepting the concept of a separate electorate. Indians for the first time in the Viceroy's Executive Council. Finally, we have the Government of India Act 1990, wherein the Dyarchy, the system of double government, was introduced for the first time for the British provinces in India. It marked the first introduction of the democratic principle into the executive branch of the British administration of India. Though much criticized, it signified a breakthrough in the British Indian government and was the forerunner of the India's full provincial autonomy of 1935 and India's independence of 1947. Dyarchy system was introduced as a constitutional reform by Edwin Samuel Montague, who was a Secretary of State for India from 1917 to 1922, and Lord Chelmsford, who was the Viceroy of India from 1961 to 1921. This act is also known as the Montague-Chelmsford reforms. The central subjects were demarcated and separated from those of the provincial subjects. The scheme of dual governance, that is Dyarchy, was introduced in the provincial subjects. Under the Dyarchy system, the provincial subjects were divided into two parts. Number 1, transferred, and number 2, reserved. On the reserved subjects, the governor was not responsible to the Legislative Council. The Act introduced for the first time bicameralism at the centre. This principle of Dyarchy system was a division of the executive branch of each provincial government into authoritarianism and popularly responsible sections. The first was the composed of executive councillors appointed as before by the Crown. The second was composed of ministers who were chosen by the governor from the elected members of the provincial legislatures. These latter ministers were the Indians only. The various fields of subjects of administration were divided between the councillors and the ministers, being named reserved and transferred subject respectively. The reserved subjects came under the heading of law and order and included the justice, police, land revenue and irrigation. The transferred subjects on the other side, that is, those under the control of Indian ministers. It included local self-government, education, public health, public works, agriculture, forest, fisheries and many more. The system ended with an introduction of provincial autonomy in 1935. Now let's discuss little about the Government of India Act 1935, that is the introduction of provincial autonomy. The Government of India Act 1935 provided for the establishment of an all India federalism consisting of the provinces and the princely states as units, though the envisaged federation never came into being. The Act divided the powers between the centre and the units into items of three lists: Federal List, provincial list and the concurrent list. The federal list for the centre consisted of 59 items. The provincial list for the provinces consisted of 54 items. And the concurrent list for both consisted of 36 items. The residuary powers were vested with the Governor General. The Act abolished the Dyarchy system in the provinces and introduced the provincial autonomy. It provided for the adoption of the Dyarchy at the centre. So now let's conclude the topic with this. The East India Company, which was established as a trading company in 1600, later on transformed into a ruling body in 1765. The British East India Company started interfering in the internal matters of the country. After the Battle of Buxar in 1764, the East India Company got the Diwani rights, which is the right to collect revenue of the three provinces, that is Bengal, Bihar and Odisha. Gradually, it started interfering in the Indian affairs. The period from 1765 to 1772 saw a duality in the system of government, where the company had the authority but no responsibility, and its Indian representatives had all the responsibility but no authorities. This resulted in the rampant corruption among the servants of the company, excessive revenue collection and oppression of the peasantry, and the company's bankruptcy, while the servants were flourishing. This Dyarchy created an inefficient and impractical system in the long run, which actually led to anarchy and chaos in Bengal. The company relegated the responsibilities to the Nizamat to various sub-Diwans, due to which the inefficiency in law and order started appearing. The company refused to accept any responsibility, while the Nawab found himself lacking the necessary means to do so. In order to have an effective administration, various acts were passed and the Adalat system was introduced by the Hastings. Indian Independence Act of 1947 declared India as an independent and sovereign state. It established responsible governments at both the centre and the provinces. It assigned dual functions, that is both constituent and legislative, to the Constituent Assembly and declared this Dominion legislature as a sovereign body. Thank you everyone for your time and attention. We have covered the entire concept in a short time, and I hope that the listeners have enjoyed and understood the topic. Stay safe, stay healthy. God bless you all. Take care.